Ladies and gentlemen, good evening. Good evening to all of you who are here at the Geneva Press Club, at the Domaine de Pont in Geneva, and welcome also to all of those following us on Zoom, as well as all the people following this conference on YouTube. So we have today an interesting, very important conference about indigenous people. And we had this type of conference a few times already, had a lot of success actually. And so without waiting any longer, I will give the floor to Ronald Barnes, to Ambassador Ronald Barnes. The floor is yours, and you represent indigenous people. You will explain us exactly who, how, and what. Thank you very much, and the floor is yours, Mr. Barnes.
Okay, thank you very much for the introduction. Of course, I am appointed as ambassador from Alaska by the majority of tribal governments, and I've been here in Geneva for 20 years working to promote the international legal and political status of Alaska. And we have had some success over the years. This is followed by recommendations after going to the UN Decolonization Committee in '97, and recommendations that we come, as some of the members in the corridor said, go across the pond and lobby the international community because no one knows about Alaska and Hawaii. And so we came to Geneva to what was the former Commission on Human Rights. We got some recommendations from the former subcommission, and we drew some attention in some of their work. And also, of course, the many years I've been here, I worked on the institution building process. The members of the subcommission offered a resolution, but we decided to put that off and wasn't able to push it through. But nonetheless, we are here. We sit on recommendations to go to the United Nations Decolonization Committee, a recommendation also from the Third Cycle Universal Periodic Review for Alaska and Hawaii and the Lakotas to go to the UN Decolonization Committee. And also we have, of course, a recommendation which Alfred de Zayas, during his tenure as the independent expert on the promotion of a democratic and equitable international order. So we've worked closely with other special procedures, but the most success, of course, coming from my good friend Alfred de Zayas.
And Miguel Alfonso Martinez.
Now, there's where we come to those who were very supportive. The late professor, we are pushing this report, the treaty study from the late Miguel Alfonso Martinez. He was from Cuba, and he made recommendations that international treaties of indigenous peoples are to be respected, that international peoples' rights include indigenous peoples, that we are to be respected with the equal right in self-determination under Article 1.2 of the Charter of the United Nations and international law. Of course, we have some very good recommendations coming from the late Erica Daes, who did say and mention the Johnson v. McIntosh case and the Tehiton case. This is a very peculiar case because in 1955 it said the land basically was for the settlement of the white race when Alaska was still a non-self-governing territory, or for some of you French-speaking people, a territoire non autonome. And then we are sitting on, from the permanent forum, the Tonya Frichner report on the Doctrine of Discovery. And so we will have some of our speakers speak on that. And of course, Alfred de Zayas will speak on his report and the recommendations coming from it. And what we sit on also, which is very exciting, and what we're also promoting is Human Rights Council Resolution 48.7. It is a negative impact on the legacies of colonialism, on the enjoyment of human rights. And this is what some people consider revolutionary, because China introduced this. It was supported by the like-minded states. It was adopted in October of 2022. And in this, it calls for implementing our rights under General Assembly Resolution 1514 of 1960, the Declaration on the Granting of Independence of Colonial Countries and Peoples. Why is this so important? The 107th Committee on the Elimination of Racial Discrimination, the CERD Committee, in August of 2022 convened, and it was the implementation report of the United States of America for the CERD, the International Convention on the Elimination of Racial Discrimination. And what CERD said is that there are two ways to implement Indigenous rights. One is through the United Nations Declaration on the Rights of Indigenous Peoples, and the second is potentially, or you might say, in fact, recognizing the international rights of particular Indigenous peoples who have international treaties or who were formally recognized under the United Nations decolonization process under Article 73 of the Charter of the United Nations. And of course, two that come to mind of great importance and why we're here. Alaska and Hawaii were placed on the list in 1946 under General Assembly Resolution 66, first session of the United Nations Charter. And we were removed in General Assembly Resolution 1469 in 1959 without due process of law. With that introduction, and I could say more, I'm going to go straight to our distinguished chief, Nemos from Canada. He is the chief of the Wet'suwet'en people, and he is the traditional chief appointed by his own people, and he's a hereditary chief. So under the law of nations and international law, under the report of Miguel Alfonso Martinez, he would be considered the real chief. And what we are talking about in this case of Canada are statutory chiefs that are appointed, basically the institutions, or in North America it would be by the IRA governments, which are created by the United States of America. And these, we believe, are not legitimate hereditary leaders of our peoples. So Chief Nemos, I will give the floor to him as he is waiting for us right now on Zoom.
I am Chief Nemos. I am hereditary chief of the Wet'suwet'en Nation. The name I carry is thousands of years old, and as stated, it was our houses, our clans, our nation themselves that choose us to become hereditary chiefs. I'd like to start off with a statement and then also do a little bit of follow-up on it. But as a backgrounder to us and why I'm speaking today, it's because we are the Wet'suwet'en peoples. You know, we've governed our lands for millennia, long before European contact. We have and continue to govern under our traditional laws as passed down generation after generation. In our language, Nuk Nuaten, our law, our way. Our 22,000 square kilometers of unceded, non-treaty, and undefeated lands are the basis of who we are as peoples who depend on these clean waters, bountiful lands, and all the sustenance that it provides for us generation after generation. Currently, all these are under threat by pipelines and other industrial activities, all without free, prior, or informed consent. The hereditary system, our laws, our peoples, have never consented to these projects. We call upon the United Nations and all its powers to stand with us to protect our freedoms and our natural environment. With Canada supporting and implementing the United Nations Declaration on the Rights of Indigenous People, the situations that elected governments of both the provincial and federal entities should not be occurring on a purported free and democratic society. The violence and harassment that our people face must be brought to the world's attention. When a country such as Canada stands on the world stage and touts itself as one of the world's most progressive and democratic countries, then these statements must be challenged. Indigenous peoples of Canada must be treated as equal humans, not ignored, incarcerated, removed from their lands, brought before the courts for simply protecting the natural environment. We cannot continue to have our Indigenous rights, our human rights, abused. We call upon all free-thinking, free-will peoples to stand with us to defend all human and Indigenous rights. The rights to freedom, to protect clean waters, lands, food sovereignty for future generations, acknowledge and know who we are as the first peoples on these lands. Canada must respect and adhere to the United Nations Declarations of the Rights of Indigenous People, as was noted in 3 letters to Canada, which they have not responded to. We met with the Special Rapporteur on the Rights of Indigenous People this month in British Columbia, Canada. He stated that accountability and ownership of Canada's treatment of Indigenous people must be addressed. And I must add to it, in December 11th of 1997, there was a Supreme Court ruling in Canada that said the Gitxsan, our cousins, our neighbors, and ourselves, the Wet'suwet'en, we exist. We've never given up our right to rights and title on our land. We've never signed a treaty giving any form of authority to anybody else except our hereditary traditional system. When Canada or British Columbia itself state that they have authority, that is only an assumed and presumed authority. The Supreme Courts of Canada have said we have never ever given up our rights and title, our authority, our jurisdiction. We are referred to as unique in Canada because of that Delgamuukw court case. And yet the governments of the day, and it's been 25 years now, they ignore that. In 2020, we took another route. We did a memorandum of understanding with the province of British Columbia and the federal government, which they signed on to. And because of the proposed pipelines and other extractive industries on our territories, they chose to ignore to this day because they will not want us recognized as the Indigenous governing body, and we are. We've never given up anything. I'd like to refer to some of the things that the UN has done, as well as throughout the world. You know, you have to look at Miguel Alfonso Martinez. He made it clear that in treaty study, a final report of Special Rapporteur Miguel Alfonso Martinez, paragraph 210, on the equal right and self-determination of peoples in Article 1.2 of the Charter, he stated that the peoples of the United Nations, who through their governments declared themselves in 1945 determined to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained, emphasizing that this applied to all peoples, bar none. That includes us as a hereditary and traditional government on our land. Professor Martinez also states that the rights of Indigenous peoples belong to the realm of international law, and there needs to be justification to determine whether or not this issue belongs solely to domestic legislation or to domestic courts, emphasizing in paragraph 194 that states should not produce unassailable proof that the Indigenous peoples in question have expressly and of their own free will renounced their sovereign attributes. We have never renounced that. In light of this paragraph, 195 observes that this process of gradual but incessant erosion of Indigenous peoples' original and sovereignty, without considering and indeed highlighting the role played by judicial tools, always arm in arm with the military component of the colonial enterprise, played a part in unjustly diminishing their rights. Concerning paragraph 265 on a colonization process, the Special Rapporteur has not found any sound legal argument to sustain the argument that they have lost their international jurisdictional status as nations or as peoples. I state that because this is who we are. We don't own this land. We are only caretakers of it for the future generations. The climate crisis that we're in, the gradual overtaking of our so-called government of democracy in Canada has to be held accountable for the actions they are doing. We are doing our very best to protect this planet, our very best to protect Indigenous and human rights, and yet we are ignored. And I and we and all humans should call upon the United Nations to hold Canada accountable for their actions. If a country such as Canada continues to be on the world stage stating how free and democratic they are, when in fact they are not, then it should be the United Nations and all peoples who call them to be accountable for their actions, the effect they'll have on the generations to come, because we hold ourselves accountable. Our 22,000 square kilometers of territory in British Columbia, 70% of our waters go down to the north coast through the Skeena River. The other 30% goes to the south coast, to the Fraser River. We take our responsibility of these waters, these lands, these airs very seriously. And I don't believe that Canada is, and they should be held accountable. Uphold the human rights of all peoples, uphold the Indigenous rights of all people, and make them accountable and say the truth that they are not following a democratic country. They are simply following a dollar. The dollar will never ever pay for the damage you're doing to the future. And the United Nations, I've had the opportunity 3 times to speak in the United Nations, twice in New York and once in Geneva, and it was on the Committee to Eradicate Racial Discrimination. So the United Nations wants to hold them accountable. Canada has not responded. I thank you for your time. Ms. Sai.
I would like to thank you sincerely, Chief Nemox. Before we proceed, I would like to ask you to do a short prayer for us as we proceed, not too long, and then I will introduce the next speaker.
Definitely. Hudakai, the one above, the one who creates this earth, the one who looks after us, the one that looks forward to our future. We thank you for this opportunity to speak, to tell the truth, and have the world listen to what is important. The future is important. What we've done in the past is important, but we can all make changes if we stand together, speak the truth, speak from the heart, and know what is right, and never be afraid to tell the truth. Messiah, thank you.
Thank you very much, Chief Nemox. And I'm going to say one paragraph, which is vitally important, from paragraph of the final Martinez study, paragraph 221. Coercion, either by armed force or by judicial and legislative means, or both, it was frequently resorted to. This was true whether or not its employment was preceded by formal juridical commitments to the contrary. And I will speak on that later, but for the next speaker, I will introduce Alice Abu. She is one of the survivors of the residential schools, but she's also a promoter of our human rights. And she will speak about our need to preserve this planet and some more of what we face and some of the background that supports us in these studies. So I give you Alice Abu.
Ma'a, wait. Can you hear me? Ma'a, can you hear me?
You gotta press on mute.
Where's it?
Right there, you're doing muted. It should be good.
Can you hear me? No. Oh, you can?
Yes, we can.
Okay. Ma'a wait kohueda and Jesuits Misquest Iganawaki. Alice Abbey is my colonial name. I am a Sisquatmo from Western Canada in the province of British Columbia. I speak as a Shuswap Nochnochan Chankea, as a Shuswap woman and a Shuswap grandmother. As the Shuswap peoples, we have 180,000 square kilometers of traditional territory in Western Canada, in British Columbia. It has been home to our Shuswap people, our Shuswapan peoples, for more than 12,000 years. And it spans a very large area, and it covers Fraser River, a lot of watersheds. And this government, this de facto government in Canada, this has bought a pipeline, Trans Mountain Pipeline, and they bought it for $4.5 million or billion dollars. And today it costs this country $30.5 billion. And this pipeline is going through our Shuswap traditional territory. And it's 500 miles of our territory. And we've taken climate action as a Shuswap people, and we've tried to stop, and using our bodies, we've tried to stop this pipeline from destroying our archaeology sites, our medicines and our plants and our watersheds and our forests. They have clear cut 500 miles of forestry for bringing this pipeline to take it down south to the Pacific Ocean. And so they could load bitumen oil, the dirtiest oil, the bitumen oil, so they can load this bitumen oil onto tankers and take it over to China. And so it's not for this country, it's not for our people in Canada, but yet it's costing the people in this country $30.5 billion to date for this so-called pipeline. And our issue, one of our many issues, one of the main issues is the statutory leaders. The statutory leaders are appointed by the de facto Canadian government of this country. So there's a clear conflict of interest. The statutory leaders sit at the negotiation tables with the Canadian government, and they negotiate for money so they can do resource extraction of our traditional territories. Our people have not given their free and prior and informed consent to these resource extraction companies or to the government. So we've been persecuted, we've been criminalized for fighting for our territories. 1,100 of our people, of the land defenders, since May of 2021 to February of 2022, 1,100 have gone to jail and have got arrested for protecting the waters, for protecting our medicines, for protecting our territory. We've taken this climate action, but we've been persecuted by this Canadian government. And the foundation of apartheid laws that is being used and exercised by this de facto government is a premise of law in Canada. And the entire Western Hemisphere is a root of apartheid against humanity and genocide that continue to be enforced, as we see, through resource extraction, forcing our people from our homelands. The Doctrine of Discovery is the foundation of how the governments have, the United States through the McIntosh case, they said that they have underlying title of all the territories, even though they do not have any proof of saleable territories. And the same thing, and Canada has adopted that through the St. Catherine Milling case, that the Doctrine of Discovery says that the lands are discovered, the lands belong to the de facto government of Canada. And all of the apartheid laws derive from that. They come from that. And we've been asking and we've been lobbying the international community to have this Doctrine of Discovery repealed. And because it affects all of the Indigenous people globally in their traditional territories. But we've taken climate action. We've tried to protect our territories. We've tried to protect the lands and all the sacred that are within the waters, the species, the forests. And the United Nations says that climate action is a human right, and it's human right, equity, and justice issue. For us in this country, it's been a persecution issue. We've been criminalized, and we've been brutalized. We've been put in dog kennels when we're arrested. And we ask the United Nations to open their doors for more collaboration and to allow us to come and ask us to come to the Decolonization Committee. Open your doors for more collaboration so that we can hold some of these countries accountable, these Western countries accountable, and that we can come up with some solutions for the Indigenous people. Okay, I thank you for your time. Kochjan.
Well, thank you very much, Alice. And thank you for giving us some background and current events that happen and the struggle that has brought so many of your people into prison as human rights defenders. And we will send this to the human rights defender mechanisms and to right to development and to other mechanisms. 48.7, the legacies of colonialism, I like to call it, resolution, does ask all the UN bodies, the mechanisms, and special procedures, which are special rapporteurs, to address these issues. But we see some of them evading and running away because they're scared of some of these states. Gary Harrison has just sent me a message saying that he's only on a cell phone and he believes his time may run out. So if he's still there, could we give him the floor? I think that would be a good idea. And this is Chief Gary Harrison from Alaska. He's one of the traditional chiefs. He and I, as I spoke before, we both went to the Decolonization Committee. He's been in this for many years. And we have others from Alaska who've been in this for many years who Alfred de Zayas knows. But without delay, I'll give him the floor if he's ready to speak.
Willie Jan, and Sudokta Kaska, Gary Harrison, Tolchina Islan, Nadeniana. Good day, I'm Chief Gary Harrison. I'm a Water Clan, and I'm from Chickaloon Village. Yes, we went there, and one of the things we learned at this in Antigua was that only the original people are supposed to vote in the decolonization. So it made us take another look at what was going on in Alaska and what they call decolonization. And what they called decolonization was when they voted for statehood. It was not true decolonization for many reasons. One is that only the original people were supposed to speak, and the law on the books was that if you were a native, you had to prove that you could speak and write English, and you had to have 5 white people sign that you were competent. We didn't have all of those people do that. And when my people tried to vote in a place called Cantwell, they got in a fist fight. So we weren't allowed to vote. The other thing is the people who were allowed to vote were the colonists themselves, which they're not supposed to. The miners, merchants, and the military and other ne'er-do-wells were allowed to vote, yet we were not. And we were the only ones supposed to vote if it was to be a vote on decolonization. So it was not a true vote. And when it is voted upon, they're supposed to do it under Chapter 11, Article 73 of the UN Charter, which the United States both helped write, and they have also signed it and codified it with the vote of the Senate and the Congress. So these are the laws that they're supposed to have decolonized with, and they have not done that. And I got to mention also Hawaii. I'm not going to talk about Hawaii, but I need to mention that they have many of the similar legal rights that we have and that have not been looked at by the United Nations. This is, just part of the problem that's going on is that they don't want to take a look at what they've done. They don't want to take actions for the genocide that they've created. When you look at Alaska, the indigenous people make up 15% of the population, yet they're over 65% in the jails. And when it comes to sentencing that other ones get, maybe probation or maybe hardly nothing, our people get sent to jail for years. And then they get out on this probation system that just puts them in a round and round merry-go-round because they have a hard time being able to do the probation. When you live in some of these villages, there's not always jobs for you to get. And that's one of the things on probation. They want you to be in a job. So you have to go live in the city, which you have no way of actually making it in the city because, well, that's the way many cities are, and you become a homeless person, and then you can't fulfill your probation, so you end up back in jail, and generally you get even more charges, so this circle just keeps going on, and the people just keep on going back to jail, even though they have committed really no crime. This is a big problem. The other thing is when you take a look at even the treaty accession, which they say Russia transferred the title to Alaska to the United States, it says in the treaty on the last page that Russia is only giving the United States what interest it has in there. And if you take a look at the Kuznetsov Memorandum Descriptive, which is what Russia sent after the United States says, well, what did we buy? It tells them that they only bought 2 forts on 2 islands and they never got into the mainland. So everything that is being done in Alaska is a big hoax by the United States. And if you look at all of the resources there, that's why the United States doesn't want to give it up. They've made how many billions and trillions of dollars off of the oil and gas, and how many trillions of dollars off of the fishing. And now we're having problems with the fishing. There's crashes of salmon all over Alaska. Many places, the villages can't fish for their subsistence, which I don't really like that word subsistence, but it has international connotations, so we use it. Because we want something other than below sustenance. And that's what sub is. It's below sustenance. We need not only sustenance, but we need to thrive. This is what they're doing to us is wrong. What we really need is we need a set aside for the indigenous people on fishing and hunting, because now we're competing with the commercial fishermen, the commercial hunters, even though they say they're not commercial, what they are is they're big game guides, which are commercial. And we're competing with the sports hunting and the sports fishing. All of these things, when something goes wrong, we're the ones cut off. We're the first ones cut off. And in many of the cases, to even hunt, you have to get into a lottery, and maybe you'll make it or not. Maybe you'll be able to provide your family with food that year. They say, well, you're not in a subsistence area. Well, if we have money, we might be able to go to the grocery store. If we have a vehicle, it's illegal to hitchhike. So we're supposed to hitchhike 200 miles to town, 100 miles to town, 50 miles to town, or be able to fly in. The laws in Alaska are really crazy when it comes to our rights, whether it's fishing and hunting and gathering or any other thing. So these are many of the problems that we face in Alaska. And as Ron said, these are the effects of colonization. We have a lot of historical trauma that they don't even want to recognize. Most of them don't even understand what it is or what it means, but it's embedded in the genes of our people from the trauma that has been brought onto them. I myself am a survivor of boarding schools. A lot of people don't know that, but I am. And anyhow, I want to thank everyone for being here, and thank you for listening to me. And if there's any points that I didn't bring up, maybe Ron can bring them up. He's very good at bringing up a lot of our issues, and I want to thank him for helping put this whole discussion together on the news. Thank you very much. Chinan.
Okay, thank you very much, Chief Gary. Thank you for your presentation. Of course, there are many issues from Alaska, and when you look at the paragraph I read, Indigenous peoples of the whole Western Hemisphere have the right to claim all of the provisions of the 1949 Geneva Conventions, especially Article 2, where we fall under peacetime occupation, simply because, as I said, by judicial or legislative means, and it says by armed force, and that's recognized by an expert. And so, of course, Common Article 2, when the Hitler regime went into the Netherlands and to other places, it would have been suicide to respond. Instead, they laid down their arms, they came in. It was still an occupation. The same thing happened in Hawaii. They did not resist. It was still an occupation. So international law recognizes that the laws of occupation does not have to be an armed conflict. Well, what I will do is give to Professor de Zayas, I would like perhaps maybe to include Ruth if she's there, because is she there? I would like to give her the floor because she's going to bring up some of the provisions of the Geneva Conventions also. Thank you. And let me just give a brief introduction. Ruth Bolame has worked on the issue of title to territory, private lands, and as a peoples under occupation by a foreign government, the Geneva Conventions has specific provisions that the occupying government has to respect. And she's been trying to promote this. Of course, it's very difficult for an indigenous, or you might say a government, the Kanakamoli peoples, the Kingdom of Hawaii, who had many treaties around this world with Russia, United States, Switzerland, etc. Now they're denied their basic means of subsistence and all of these other rights as a nation under occupation by United States of America. And she's a descendant, she's a descendant of the Kamehamehas. I present you Ruth Bolame.
Aloha kako. Bonsoir, everybody. Good evening. This evening, I'd like to talk about mostly the Hawaiian Nationals' obstruction of inheritances of private lands, their wrongful takings, and other ongoing egregious human rights violations going on in the Hawaiian Islands. I became aware of the human rights violations 12 years ago when I applied for a state of Hawaii land tax exemption and was denied based on an 1864 Hawaiian Kingdom law that made Kamehameha III's private lands unalienable. I learned the land my husband and I bought actually was owned by Kamehameha III, and later I would come to learn that I was also heir to these very same lands. Essentially, I bought my own inheritance that was prohibited from sale. In 2006, my husband took out a line of credit that used these same unalienable lands as security. Learning that these lands had a defect triggered a clause in the mortgage security agreement that we had to notify the lender so that the lender's title insurance policy could be invoked. And now the unsecured promissory note would be paid off to minimize the injury to the shareholders of the trust holding the line of credit. Unfortunately, what was supposed to take 90 days became the key that opened up Pandora's box. You see, this revealed a fraud so entangled in deception that went far beyond my 1 acre property. This unveiled securities frauds, human rights violations, war crimes, theft of Hawaiian international protected persons' inheritances, and a whole lot more. It's been 12 years since I began this journey, and unfortunately, it's still not resolved. For you to appreciate the full gravity of the situation, I'll give you a little historical background. It starts in around the 1840s when imperialism was spreading across the Pacific, and there was an attempt to overthrow the Hawaiian Kingdom in 1843. This motivated King Kamehameha III to move kingdom lands into private native hands. Portions of the lands were given and sold to chiefs and commoners in the Hawaiian Kingdom with royal patent allodial titles. This was absolute ownership, free from taxation, policing, and eminent domain without compensation. This generous sharing by King Kamehameha III began in 1848 through what we call the mahele, or the sharing. By putting lands into the native private hands, the king could minimize the takings of a kingdom's holdings should another ambitious imperialistic takeover occur. Kamehameha III kept for himself his own private lands made inviolable in the Hawaiian Kingdom Constitution. These lands became known as the king's private lands for himself, his heirs, and his successors forever. In 1854, our beloved Kamehameha III died, and through his last will and testament, he named his heirs and successors. Today, only 2 of the 4 named heirs have lineal descendants, that being Queen Hakalelepone Kalama and Crown Princess Kuhinanui Victoria Kamamalu. In 1864, King Kamehameha V, in an effort to preserve the king's private lands, passed the Hawaiian Kingdom Legislation Act 34, making the private lands of Kamehameha III unalienable with only a maximum 30-year lease period allowed. Up to January 17, 1893, the king's private lands and income was never intermixed with Hawaiian Kingdom government's accounting. However, the Republic of Hawaii seized these private lands as kingdom private property, depriving the Kamehameha III's heirs of their inheritance. The Hawaiian Kingdom throne was usurped with the assistance of the U.S. consulate and the U.S. military. The usurpers later called themselves the Republic of Hawaii. An investigation was launched by U.S. President Grover Cleveland, and upon reading the report, he called these actions by the U.S. consulate and the U.S. military an act of war. It was the Republic of Hawaii who, with the United States, executed a fake execution giving their interest in the Hawaiian Kingdom assets of whatsoever kind to the United States of America. However, since the Hawaiian Kingdom had not ceded any portion of the Hawaiian Kingdom or government assets to the usurpers, the Republic of Hawaii had no interest of any kind in the Hawaiian Kingdom assets, and therefore nothing could lawfully be transferred to the United States. In 1897, the majority of the Hawaiian Kingdom, Hawaiian nationals banded together and protested against the U.S. annexation of the Hawaiian Islands through the Kauai petition submitted to U.S. Congress in 1897. This stopped the treaty, the alleged treaty of annexation. However, despite the protests and despite that this didn't initially pass, the U.S. President McKinley pushed through U.S. Congress with U.S. domestic laws, an annexation that was memorialized on July 7th, 1898 through a joint resolution. In 1959, the U.S., through the United Nations, orchestrated a huge fraud upon its treaty partner, the Hawaiian Kingdom, Kamehameha III's heirs, and upon Hawaiian nationals, and more importantly, upon the UN member states, when it gave the illusion that it met its UN Charter Article 73 obligation through its A4226 report submitted on 24 September 1959. The US stated that the people of Hawaii voted to have Hawaii become the 50th state in their unsupervised UN referendum that wasn't supervised by the UN. Well, that's only half the truth, you see, because American settlers and US military personnel could vote, and they outnumbered the Hawaiian nationals. And Hawaiian nationals could have participated, but only in their capacity as a US citizen. So, as it was mentioned earlier, only Hawaiian nationals should have voted in this referendum. In the 1959 referendum, you'll see it consists of 3 questions, none of which gave an option for self-governance. The boundary description referred to in US Public Law 86-3 excluded all of the Hawaiian Islands. And in question 2, in part, it said, all claims of the state to any areas of land or sea outside the boundaries so prescribed are hereby irrevocably relinquished to the United States. Since all the Hawaiian Islands were excluded, does this also mean that it included all the islands on the planet were also irrevocably relinquished to the United States? Are we to assume that this also includes all the islands in Japan, Indonesia, Venezuela, all the Pacific Islands, Great Britain? How about Taiwan? How about Crimea? It's merely the infringement upon our nation's name, Hawaii, that gives the appearance to the world that Hawaii, the 50th state, is located in the Hawaiian Island archipelago. It was because of this deceptive boundary description that Dr. Alfred de Zayas wrote in his February 25th, 2018 memorandum to the judges overseeing my cases, in part, that the lawful political status of the Hawaiian Islands is that of a sovereign nation state in continuity, but a nation state that is under a strange form of occupation by the United States resulting from an illegal military operation and a fraudulent annexation. As such, international laws, the Hague and Geneva Conventions, require that the governance and legal matters within the occupied territory of the Hawaiian Islands must be administered by the applicable laws of the occupied state, in this case, the Hawaiian Kingdom, not the domestic laws of the occupier, the United States. And under the Geneva Convention 4, Article 47, it says the occupying power cannot deprive the population of an occupied territory of the protection afforded by international humanitarian laws. And under those laws, the people of the Hawaiian Islands are internationally protected persons, and under no circumstances can protected persons be deprived of their rights or coerced into renouncing their rights. That's under Geneva 4, Article 8. And amongst the many humanitarian laws of occupation, there were two that address private property. One stating that reprisals against protected persons or their property are prohibited. And the second, the confiscation of private property by the occupier is prohibited. To date, the UN and the Human Rights Council appears to selectively pick and choose who are entitled to protections, stepping over the harms and injuries being suffered by Hawaiian nationals. Hawaiian nationals have their identities stolen. They're turned into US 14th Amendment fictions, have securities created, bought, sold in their names without disclosure or consent, have all of their Hawaiian Island assets transferred to the fiction without their knowledge and consent, and the natural common law man and woman are unlawfully bound to the fiction's liabilities, to include being enslaved, to pay off the US's multi-trillion-dollar debt, contra to the Hague and Geneva Conventions. Many Hawaiian national natives are without homes, many work multiple jobs and still can't afford rentals, and yet they are more than likely an heir to at least a quarter acre of land and possibly more. US and state of Hawaii agents, agencies, actors, and contractors conspire to obstruct our inheritances to our private property that are not within their jurisdictional authority. Now, more than ever, I see that we all have to step up to do our part with our talents to guarantee that there will be a future for our children that is even more promising than what we had. These are exciting times and scaring times, and it's not an option anymore for us not to do anything. Merci beaucoup for the opportunity to speak this evening.
Thank you very much, Ruth. It was a joy having you. It brings to mind the concept. Say that again?
I said thank you for having me.
Okay. The issue of taxation without representation and consent of the governed is one of the founding premises of the American Revolution. And I like that you brought up the taxation issue. I refused to pay tax on my boat. And what we discovered is that my boat, of course, is still sitting there, but the city who was trying to tax me, when they voted in the city, only whites could vote. So they were afraid to implement, because we put all the way up to the President of the United States on notice, because under the US laws, if you attempt to violate the Constitution of the United States, enforce its illegal laws, they could be sued, they could be held privately accountable in their official capacity. So my boat still sits in the boatyard. Well, I'm going to move right now to Alfred de Zayas.
Very brief.
Okay, because
Look at the time.
Yes, I know, but because we have one more speaker after. Mr. Leon Su.
I'll be very brief.
Okay, very good. Okay, thank you. Alfred, you have the floor.
First of all, my thanks to the Geneva Press Club, to Ambassador Barnes, to my very knowledgeable preceding speakers whose statements I endorsed. Very briefly, as professor of law at the University of British Columbia, at the University of Chicago, at the Haute Études Internationales, at the Geneva School of Diplomacy, I must confirm that the doctrine, or the so-called doctrine of discovery, is totally incompatible with the United Nations Charter. In Australia, it was tested in the Mabo against Queensland case, and it was rejected because obviously you cannot discover inhabited territory. You can only discover terra nullius. Now, not only is it incompatible with the United Nations Charter, it's incompatible with the Universal Declaration of Human Rights, with the whole philosophy of human rights. Endorsing what was said by Chief Harrison, I myself was in Alaska back in 2014 on official mission, And I used what I learned in Alaska in my 2014 report to the General Assembly, which was entirely devoted to the theory and practice of self-determination. I subsequently participated, there were 3 other co-authors, in a memorandum, which we did on the necessity to revisit General Assembly Resolution 1469. It is obvious that this was fraud on the people of Alaska and of the people of Hawaii. It was fraud on the United Nations. It was fraud on the world. And this must be revisited. And it can be corrected. Look at the advisory opinion of the International Court of Justice in the case of the decolonization of the Chagos Islands. Look at any number of resolutions that they're there on Palestine, on Nagorno-Karabakh, on the self-determination of Kurds and others. It is now the time. China took the initiative with Resolution 48/7 of October 2021. That calls on all United Nations agencies and all rapporteurs to deal with these issues as a matter of urgency. And I wish specifically to endorse what Ruth said with regard to the simply outrageous application of United States domestic laws on the people of Hawaii. Now, what does Resolution 48/7 tells you? Among the fact that we have to address the legacies of colonialism and the legacies of imperialism, no one has used the G word, but I'm going to use it. And I'm going to quote Martin Luther King Jr. In his book, which you can buy, it's still in print, Why We Can't Wait. It came out in 1964. And I have the original also. I just don't bring the original. In any case, page 141. Just listen to this. Our nation was born in genocide when it embraced the doctrine that the original American, the Indian, was an inferior race. Even before there were huge numbers of Negroes on our shores, the scar of racial hatred had already disfigured colonial society. From the 16th century forward, blood flowed in battles over racial superiority. We are perhaps the only nation which tried as a matter of national policy to wipe out its indigenous population. Moreover, we elevated this tragic experience into a noble crusade. Indeed, even today, we have not permitted ourselves to reject or to feel remorse for this shameful episode. Our literature, our films, our drama, our folklore, all exalted. Once again, Martin Luther King Jr., Why We Can't Wait, page 141. Now, I have incorporated that quote into my human rights trilogy. I published in 2021 with Clarity Press in Atlanta, Georgia, Building a Just World Order, which is based on my 14 reports to the General Assembly and to the Human Rights Council. In my 2018 report to the Human Rights Council, I formulated 25 principles of international order. Principle 10 being the principle on self-determination. In countering mainstream narratives, I show why the problem. The problem is that people do not know. We have an information war, and very few people know what has happened to the indigenous of America, and I'm talking not only about the Alaskans, I'm talking also about the Squamish, I'm talking about the Crees and the Cherokees and the Pequots and the Sioux and the Navajos, etc. They just don't exist. And you have to realize, and that's why Martin Luther King used the word genocide. When the Europeans arrived in America, there were 10 million indigenous north of the Rio Grande, in the areas that today are United States and Canada and Alaska. At the end of the 19th century, there were 200,000 left. They have recovered a bit. There are about 2 million of them now. But in any event, in South America, it was difficult to exterminate 70 million people who were living in the areas that are today Mexico and Central America and Brazil and Argentina, etc. But millions were also killed. Don't just simply try to escape the responsibility by saying, oh, what a pity, they all died of disease. Oh, they all died of European diseases. They all died of smallpox. No, they didn't. Maybe 50% of the loss of the population, but we destroyed their crops. We burnt their crops. We killed their buffalo. And we destroyed their sustenance. Of course there was a genocide, but nobody wants to say it. No one wants to take the responsibility. And that is the importance of General Assembly Resolution 48/7. I am now keen to listen to Leon.
Okay, without hesitation, let's bring on His Excellency, Mr. Leon Su, the Foreign Minister of Hawaii, so you can play his video.
Aloha, and thank you for inviting me to be on this special panel. And I want to greet all of the members of this panel, particularly Ron Barnes and Dr. Alfred de Zayas. Aloha.
Aloha.
The Kiwane Foundation wishes to call to the attention of the Human Rights Council the ongoing flagrant violations of the human rights of the people of the Hawaiian Islands by the United States of America. These flagrant human rights violations are the direct result of a serious breach of international conduct, namely the prolonged illegal occupation of the Hawaiian Islands by the United States of America. The human rights situation in Hawaii constitute international wrongful acts and therefore demands international intervention and remedy. These violations have been repeatedly reported to UN bodies such as the Human Rights Commission, the Human Rights Committee, the Committee for the Elimination of Racial Discrimination, and the Human Rights Council in the forms of shadow reports, petitions, and interventions, but to no avail. The specific reasons for the U.S. annexation of Hawaii were set forth by both U.S. Senate and U.S. House reports accompanying the joint resolution of annexation. They flatly stated the U.S. need of the Hawaiian Islands to control the North Pacific. The annexation of Hawaii was not achieved by any legal means pursuant to U.S. law or international law or Hawaiian Kingdom law. There were two failed attempts by the U.S. to annex the Hawaiian Islands by treaty in 1893 and in 1897. Following those failures to pass a treaty, the United States resorted to outright deceit by using an illegitimate joint resolution of Congress to make the United States' unlawful annexation of the Hawaiian Islands appear to be a legitimate acquisition by the U.S. In 1946, the U.S., ignoring tenets of international law and principles of the UN Charter, concealed the true status of the Hawaiian Kingdom as a sovereign state under occupation and falsely presented Hawaii as a territory of the U.S. to be decolonized. Thus, Hawaii was listed by the UN General Assembly as a non-self-governing territory under the administration of the United States. The United States began immediately to draft legislation to impose statehood on Hawaii. The first statehood bill was sent to Congress in 1947. Hawaiians filed suit in 1948 to stop the expenditure of public funds to propagandize for statehood, but U.S. territorial courts denied their petition. On September 17, 1959, the United States informed the United Nations that a new constitution had been adopted in Hawaii and that a referendum was conducted and that the people of Hawaii consented to be incorporated into the United States, and that the U.S. had indeed inducted Hawaii into the U.S. as a domestic state and would no longer transmit information about Hawaii as a non-self-governing territory under Article 73E of the Charter. The ballot for statehood referendum by which Hawaii was incorporated into the United States did not provide the options required by UN procedures for decolonization, that it be a legitimate exercise of self-determination, nor did the United Nations supervise the referendum. Consequently, there were two serious irregularities showing U.S. manipulation of the UN's decolonization process in order to create the appearance that Hawaii had voluntarily become the 50th state of the United States. The most egregious human rights violations in the Hawaiian Islands stem from the illegal prolonged occupation of Hawaii by the United States under a facade of legitimacy endorsed by the UN. What Dr. Alfred de Zayas, a former independent expert for democratic order, calls in a 2017 memorandum a strange form of occupation. Today, Hawaiians as a group are the poorest and most disadvantaged of all peoples in the Hawaiian Islands. This is definitely tied to the denial of the right to self-determination, to which they are entitled by natural law, legal precedents, customary international law, and further confirmed in the ICCPR and the UN Charter. Hawaiian nationals, the descendants and subjects of the Kingdom of the Hawaiian Islands, retain their right to seek appropriate redress for the wrongful taking of their country and the subsequent denial of their right to self-determination under the UN Charter. Hawaiian nationals and subjects emphatically maintain their diplomatic protest, initially filed by Queen Liliuokalani on January 16, 1893, against the United States for landing an invasive force to depose her and seize control of the Kingdom of the Hawaiian Islands. We continue to diplomatically protest the United States' presence and operations in the Hawaiian Islands. In light of the historical facts underlying the overthrow of the Hawaiian Kingdom, to which the U.S. admits, and the current status of the Hawaiian peoples as wards of the state of Hawaii, and in light of Article 1 of the ICCPR, how does the UN intend to rectify the violations of human rights of Hawaiian nationals, particularly their right to self-determination? I thank you for this opportunity to speak. Mahalo.
Thank you very much, Your Excellency Leon Su, my friend. Of course, I've been to Hawaii, been with them, was there for their 1893 overthrow centennial. And of course, in Alaska, the US military was paid $5 to vote yes, which Alfred discovered. I know. He was there. And so there's so much fraud that we can continue speaking. And I want to give Alfred and maybe speak a little bit more, but I also because it's 7:45, I want to see if there's anyone else from the journalists who may want to ask questions, or someone who has called in from Zoom. And just to remind you, we have some food afterwards. So is there anyone raising their hand right now? Okay. Oh, we have one question here. Could you stand up, or maybe he's bringing you a microphone? Yes.
Roswitha Grass, thank you very much for your enormous endeavor for a better world. And I would just like to add a very short message of hope, as we have reached the darkest point in history, which will not last much longer. We are moving in a completely new era of synthesis, peace, and harmony, and we are now experiencing the birth pains of a new civilization. This is a cosmic fact, as we are moving out of the age of Pisces into the new age of Aquarius, which will last for the next 2,300 years approximately. And always when we change from one age, the hierarchy is sent as a teacher, like before Rama, Krishna, Zoroaster, Buddha, and now it is Maitreya who is the teacher for the entire age of Aquarius. That is why Maitreya, the world teacher, is now for all humanity, for people of all faiths and for those of none, and architect for the global transformation, is now together with 14 masters of wisdom in a physical body in the world, ready to guide us through this difficult transition. And they cannot just come and interfere with our free will. They need an invitation to work openly together with humanity. Let us therefore now all invite them.
Yeah, do you have a question? Because we would like to, we have to wrap up.
But
Yeah,
this is important, it's one sentence. We
Yeah,
need to invite them.
It's good, but let's wrap up because
yeah.
Do you want to react to that? Thank you, ma'am.
We need to invite them.
Because we have another question online.
Oh, we have
also.
a question online.
Let's
So
take
we'll,
the question
let's
online.
take the question immediately.
Okay, I'll take you the question online. 1 second. So, question online from Caitlin Kennedy. Joe Biden has approved the Willow oil drilling project in spite of the clear opposition from the indigenous people living in the immediate area. What will be the implications and impact if that project, like so many others mentioned today, is allowed to go forward without robust international pushback?
Thank you very much, Caitlin. Of course, Caitlin Kennedy, she's an American journalist living in Germany, and she wrote this, Alaska is an apartheid state, which brought so much attention into the United Nations. The Willow Project is in newspapers all over the world now. I've been on the phone with the mayor, Rosemary, from Nuiqsut, and she has been working busy. She was supposed to speak tonight and explain that they have major suits, not only that they are partnering with environmental groups, but the message she brings is that there are puppet governments. There are also institutions created in Alaska that are drawing manufactured consent. The real people from the village are not able to consent, and they're put under so much pressure. She described one situation where about the porcupine caribou herd and its migration that this will disturb. And also, you can imagine in Alaska and major parts of the north, including Alaska, is a migration for many birthing ground for birds from all over the world, from South America, from the islands in the Pacific, from Australia. So she described where they are becoming vulnerable. So this will affect our environment in many ways that you cannot imagine. I only wish she would have called in and spoke and gave, because she gives such pressing testimony. She's sent to Biden, she's sent to Deb Haaland, who is the Secretary of Interior, to no avail. They're listening to what we call the puppet governments, and also the Alaska delegation. Of course, the Alaska delegation itself is an occupying force, voted in by the white race. The Tehiton case says it very plainly. The land is for the settlement of the white race. We were barred from voting, and not until 1971, which I understand 71 is when finally the women got to vote in Switzerland. Yes. So we're fighting injustice all over the world, and I think Kennedy, and I would like to direct her, I'll call her on the phone, and I will direct her to some of the people in Alaska so she can do another report on Alaska.
Pick up on that. Okay. Since you mentioned the Tehiton case, and Ruth read out of one of my memoranda, let me just give you a little touch of a memorandum that I did in my official capacity as independent expert in 2018. The United States Supreme Court instituted doctrines of superiority and racial discrimination in law and practice in the T. Hinton v. United States of America case and in the Johnson v. McIntosh case, which held that the character and religion of the native inhabitants of America justified, now quote this one, listen to this one, considering them as a people over whom the superior genius of Europe might claim an ascendancy, unquote. The denial of the right of self-determination on grounds of racial discrimination and the application of doctrines of superiority constitutes obviously a crime against humanity tantamount to a form of apartheid, quote unquote, from my memorandum that, of course, was also given to the president of the then Human Rights Council, etc. All of that, as I said, reflected in my human rights trilogy. But the third book, which is coming out now in May, has the title, The Human Rights Industry. And what does that tell you? I could have said human rights apparatus, human rights family, human rights system, etc. I'm saying industry because it has become an industry. And many of these human rights industrialists are in the service of Wall Street, in the service of the military industrial complex, in the service of actually the hawks and the warmongers who are making tons of money. You talked about the new age of Aquarius. Well, what we need more than anything else is peace. What we need today is rationality. And I don't see much rationality coming from Washington or from Brussels. I'm very worried, like my very good friend, Professor Jeffrey Sachs from Columbia, who's written any number of articles recently and have been on television quite often, warning, no, we are moving toward World War III. You have to de-escalate. That is priority number one, because if we, for a European Karel, whether Donbass is in Ukraine or in Russia, that is totally irrelevant to the populations in Latin America, in Africa, in Asia. This is our personal Karel, and we're not going to risk blowing up the planet because of this Karel. And I just find that my president, I'm an American citizen, I think that we are not a democracy. Unfortunately, we're an oligarchy, and there's no way, whether I vote Republican or Democrat in the United States, I only get the military-industrial complex, and they are the ones who govern. As I wrote in one of my reports, those who are elected do not govern. Those who do govern are not elected. Thanks.
Thank you very much, Alfred. That needed to be said because when some of us brought this case, T. Hinton v. United States, or the J.V. McIntosh case, which on February 27th and 28th of last month is 200 years old. It's the foundation of apartheid. If you look at the Doctrine of Discovery by Tonya Frichner from the Permanent Forum, it's all over the world. It's everywhere. And people, when I said this land is for the settlement of the white race in Alaska, they would look at me like I'm crazy. I'm exaggerating. But when you read these cases, you have to. I finally convinced him in 2018. He said, "Does it really say that?" I pulled out my cell phone and I said, "Look," and it says that, of course. So we have 5 minutes, and is there
I don't know.
anyone else?
We have to leave at 8 o'clock, so if there's a drink or any kind of reception, let's do it.
Well, we have some food afterwards. Okay, I'll make my closing statement. I will say that we have double standards that are happening all over the world. Double standards in human rights. Of course, in the last 60, 70 years, the legislation that was built in Canada which resulted in the taking of the children in the residential schools by the British Crown, by Canada, the residential schools in the United States and the Americas. That is crimes against humanity. That is apartheid. That is genocide. Do we hear about this in the courts in Europe? We only hear from one aspect. We never hear of other parts.
Well, you don't read it in the Tribune de Genève. You do not read it in Le Temps. You do not read it in the Neue Zürcher Zeitung, and certainly not in the New York Times or in the Washington Post.
Or the Guardian or the New York Post. So we have a lot of work to do, and we informed as many people as we could. Supposedly, this went out to about 2,000, and we have a number who said that they would watch online or watch it later. There's many things going on in Geneva. It's the Human Rights Council. But I'm very appreciative, especially of Caitlin Kennedy calling in, because she wrote this article that created so much attention, and I hope we can work with her to do another article. There is interest from other journalists. We just need to approach them. So with that, I'd like to thank all of you who came here, and hopefully we can do this again, do a follow-up, and get more written material and international law, not only articles, but also journalists who will write about our cases in Alaska, Hawaii, Canada, the United States, the Pacific, etc. So with that, I'll close. I'll say thank you. It was very good to have you, and we'll see you the next time. Good night.
Good night. The best book on the residential schools, Tamara Star Blanket.